So hi, it's Gene Trowbridge. You found our YouTube channel. That's great. While you're here, be sure to subscribe. And this is the YouTube that's involved with discussing should I file a Form D. I'm the founding partner of Trowbridge & A. I was a syndicator for 20 years, building self-storage facilities. And I've been a real estate broker for seems like forever, 40 years as a CCIM senior instructor. But when I went to law school at 45, I went there so I could change my career and become a securities attorney. I've been active in the securities business for 20 years. I wanted now to be an attorney in the securities industry, and that's what I've done. I wrote a book a while ago, but the fourth edition is out. It's called It's a Whole New Business. I'll show you how to get a copy of that if you'd like at the end of this presentation. And for my freedom, my spare time, I'm an old runner. I run 2 or 3 half marathons a year. As I get older, my times get slower, but I still do it. Keeps me active. So let's talk about this issue. And it comes from what are the rules in Regulation D? Well, what the hell is Regulation D? Regulation D is the law in the securities industry that lets you do a private placement. And what's a private placement? It's a way where you can raise money from investors without going through the full-blown registration process at the SEC. This is big business. Private placements in the last year that the SEC quoted statistics was right around $3 trillion a year in money raised. That's more than is raised in new offerings on Wall Street every year. So this is where you go, where most of us are going to go if we want to raise money and not go to Wall Street itself. And in Regulation D, there are a couple of rules. The first rule defines what an accredited investor is, and you've all heard that term. That's an important rule. The second rule establishes really what I'm concerned about most is disclosure and solicitation. The rule on disclosure tells us we need to have a PPM, a private placement memorandum, and solicitation tells us when we can or cannot advertise. That's what's important in Rule 502. The rule we're talking about, Rule 503, says it requires the filing of a Form D. Rule 504 establishes an offering exemption for offerings less than 10 million, and then most of the money is raised in Rule 506. Regulate 506 could be 506B or 506C, but that's not the issue here. The issue is Rule 503, requiring the filing of a Form D. What is a Form D? Well, you can find a Form D if you jot down this website. Just go to sec.gov, look at files and look at Form D, and you'll get a PDF of the Form D. And I believe we have a QR code here that will also get to you to that document. It's a lengthy document, and the rule says it has to be filed electronically within 15 days after the investor's money is irrevocably committed, which means spent. If it's in a real estate deal, we close the real estate purchase, and we have to file the Reg D within 15 days. If it's a business opportunity, as soon as we raise some money from investors and the investors start investing, we have to file the Reg D form. And then the states need copies of the Reg D form. Every time we find a state in which we're going to have an investor, we have to send a copy of the Form D to the state, just one per state, no matter how many investors there are. But that puts the state on notice that we're in there dealing with their citizens, and that's important to the state. So what's the purpose? It's just information gathering. And I've listed a bunch of things that are in a Reg D, a Form D. They want to know who the heck is raising the money, who's the issuer, where's their place of business, and how do we contact them? Who's involved? Is there a manager? Are there many managers? What industry are we talking about? Are we talking about high tech? Are we talking about real estate? What's the issuer size? Are we going to raise $1 million or $100 million? What exemptions are we using? In our world, we're using Regulation D. What type of filing are we doing? Well, we're doing a 506B or a 506C. Duration of the offering. Generally, a Form D is good for 1 year. We can always issue an amendment, file an amendment to extend the money raising period for more than 1 year. What type of securities offering? Is it a blind pool? Is it equity? Is it debt? What about a business combination transaction? Well, that would be, is this a merger and acquisition? We're combining two companies and two outstanding securities offerings. What would be the minimum investment for each investor? Is anyone getting paid compensation for selling the securities? What is the size of the offering? Tell me about the investors. Are they accredited? Are they non-accredited? And once again, a different type of question about sales commissions and finder's fees. And what are we going to do with the proceeds? How is that money going to be spent? How else is it used? Well, as I said, it's used to file the state notice, which is required in every state where the sponsor finds an investor for the offering. And it has to be filed within 15 days of the money being irrevocably committed. Well, in our firm, what we do as soon as we give our clients the final documents so that they can go out and start raising money, we file the Form D. We're never late. And there's nothing wrong with filing the Form D before any money is raised. It just has to be filed within 15 days of the money being spent. So we do it ahead of time. Then we're on our clients' radar to make sure they tell us they tell us about when is the money being spent and who are the investors. And in a real estate transaction, it's pretty easy. The money is spent on the day of the closing. We ask our sponsor to give us the list of investors and the states where they come from. Then we'll file the state notice and we have to get it to them within 15 days. Some states allow it to be electronically filed, and some states you have to send it by mail, so it has to be postmarked. Or Hawaii, it has to be received within 15 days. So that's all something our office does, and your securities firm's office will do for you. There was a recent SEC release where some sponsors chose not to file, and generally they chose not to file because they don't want to disclose information. That's about the only reason I can think of, because it doesn't cost anything to file a Form D. And yes, it does. If you file a Form D, then you should do the state notices, and the state notices cost roughly, on an average, $300 a state. So maybe you don't want states to know that you're raising money, and you don't want to file the notice in the state. So those are some of the reasons. But according to an SEC release, 3 sponsors were fined for failing to file their Forms D in their securities offerings. And here is the place you can go to the web and go to the SEC website and find this particular release if you want to read all about it, but I'm going to give you some important parts on it. In the release, it talked about a couple things I'm interested in and you should be interested in. The first question is, will you lose your exemption because you did not follow Rule 503? Exemption from what? Exemption from having a full-blown public offering. Regulation D gives you 5 rules. If you follow those 5 rules, you will be exempt from filing a full-blown registration. Every security has to be registered with the SEC unless it's exempt. And if you lose your exemption, then you're going to be accused of selling unregistered securities, which could be civil and it could be criminal. So do you lose your exemption if you don't follow that rule? Interestingly enough, the release that came out said, while a failure to provide such notice, which is Form D, does not result in a loss of the exemption from Section 5, which is the overall securities rules, the failure to comply with the requirements in Rule 503 is a violation of the Securities Act. Okay, so maybe you're not going to lose your exemption, because we always claim 2 exemptions. Exemption 5 is a big umbrella exemption, and Regulation D is a smaller specific exemption under Rule 506B or C. You won't lose your exemption under Section 5, but you will have a securities violation under Regulation D. So that's important. So what if they didn't file? Number 2, getting fined by the SEC. Probably you will be. The 3 fines issued in this release I referred to were a $60,000, a $175,000, and a $195,000 fine. Those should get your attention. No matter what your reason is, why don't we just go ahead and file the Form D? In our firm, every offering files a Form D, and it's always filed within the 15-day provision. Sometimes we have some trouble with getting the state notices filed within 15 days, and that trouble is always because the sponsor doesn't get us the name of the investor and the state that their residency is in time. They either get too busy or they don't think about it or whatever, and we hound them. We ask them to comply. It's in the fee agreement. All over the place, we ask them to comply, and sometimes they just don't. Well, as long as we have the Form D filed, we won't be in trouble with the SEC. We may very well be in trouble with the state. And the state sends out notices if someone calls and said, I bought an investment through Trowbridge Equity Group, and the state looks and sees there's no state notice filed for Trowbridge Equity Group, they'll go to the SEC. They'll see if there's something filed at the SEC, and maybe there is a Form D filed. Now they'll know who to contact, and they're after you. If there's no Form D filed, they'll talk to the investor who's complaining and get the current information and go directly after the sponsor. So the SEC can do fines, and the states can do fines, and actually the state could do a civil lawsuit against you. In our firm, we take the responsibility for filing the Form D for our clients, and it's always done within 15 days. So all this information really is summarized in the section of my book on securities laws, where we talk about what you have to do. So you can get a free PDF of my book by going to book.tnllp.com, and you'll get a free PDF. There you can also order a copy of the book if you just pay for shipping, which is less than $10. And I think I tell you there that there's an Audible version of my book on Amazon. And so that's all good. And I think there's a lot of great information in there. The 4th edition, it always gets updated with the newest securities laws. So once again, Gene Trowbridge of Trowbridge Law Group, Trowbridge Law Group. Don't hesitate to contact us with your questions. You can call us. You can go to our website and sign up for a free 30-minute consultation with one of our attorneys, or you can stay in the YouTube channel. Be sure to subscribe. Stay in the YouTube channel and see all the other YouTubes we have about different issues in the securities industry. So thanks for watching, and we'll see you again.